Welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law and probate attorney in New York. Today's topic, I'm going to talk to you about a non-attorney drafted will and the witnesses to that will from 25 years ago. It's a mouthful, but that's today's topic. Before I get to the topic, if you would like to make an appointment to discuss your elder law issue, please reach out to me, frankbrunolaw.com. Recently, I was hired to probate a will. The will is 25 years old. It's from it was a pre-printed form. I don't know that Staples was around 25 years ago in the early 90s. Maybe it was, but it was a pre-printed form. And it was, I don't know who actually did it. It was not done by an attorney. It was witnessed. So in New York State, a will has to be in writing. It has to be signed in front of two witnesses. And that's it. This particular will had three witnesses and it was notarized. So this is really quite an approach. A pro se person, perhaps the spouse of the decedent, perhaps the decedent directly prepared this will, then asked three witnesses to come in. Now, the situation is as I'm about to lay it out. Of the three witnesses, one person is deceased. One person, we have an awareness of who that person is and where they reside. And the third person, by address, appears to be a neighbor. However, we cannot read the signature. It's not printed below. There's no name. We do have an address, and we did put out a letter. But the letter has to be addressed to John Doe, Jane Doe, because we can't understand the writing. It could be Jonathan, it could be Edward, it could be Samuel, right? Depends on how people loop their cursive writing. But the circumstance, the reason we need to get in touch with these witnesses is because, for a few reasons. The witnesses to a will must sign a document when we probate the will. So they have to sign declaring that they were the witnesses, and a series of things, right? That's not the issue. We just need them to be available. We need two witnesses to a will. The person that is deceased cannot sign. The person that's in our control can sign. But this third person is an unknown entity as of right now, trying to track this person down. Because the will was not executed by an attorney, there is no presumption of validity. We cannot assume that it's a valid will. So the march goes on. I tell you, you should get an attorney prepared will, an attorney executed will. It's your best course of action. If you want a will substitute, get a trust. The trust should also be prepared by an attorney. If you'd like to discuss the facts of your life and circumstance, please reach out to me, frankbrunolaw.com.